Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortune of others. To help increase your legal knowledge, please hit the subscribe button. It helps the channel grow. For today's case, we have the case of John Higgins versus Kentucky Sports Radio. John Higgins is a NCAA basketball referee, and he refereed a match that involved Kentucky. And he made some calls that displeased some people, and it came to hurt his business. So he's suing for the things that people said about him and the damage to his business because of displeasure with certain referee calls he made. Let's get started with this. Devoted sports fans are not known for their even-handedness in judging referees. The sign of a true fan, it might be said, is the hopelessness of obtaining such equanimity. Veteran referee John Higgins surely was no stranger to this phenomenon before March 22nd of 2017. But what he experienced after that game day was extraordinary after the same. The Kentucky Wildcats and their supporters were upset about the outcome of a closely fought contest. They directed much of their frustration towards Higgins. You know, the Wildcats coach Calipari said in a post-game conference, "It's amazing that we were competitive in a game where the referees practically fouled my team. Amazingly that we had a chance." They do not approve of the ref's call. After the game, Higgins gained a high-profile critic in the form of Matthew Jones. A popular talk show host, Jones runs a 2-hour call-in show on Kentucky Sports Radio, which broadcasts to over 40 Kentucky stations. In post-game coverage, Jones criticized the way Higgins called fouls and didn't call them. He described the officiating as putrid and pointed out that Higgins had been part of some of Kentucky's most painful losses. The criticism grows. He added that he sat behind Kentucky's coach for the game, and the coach claimed the Wildcats got jobbed in the officiating of their fouls. There is some displeasure. Soon after the game, fans discovered that Higgins, the referee, also had a side hustle, or a main hustle, I guess, because referees don't get paid that much. He apparently also owned a roofing business, WeatherGuard Roofing. Its URL is www.rooferees.com. A portmanteau of roof and referee. Well, I immediately hate him. He's a website for roofing called Rooferees, because he's a roofer and a referee. That's great. That's fantastic. Okay. A video posted by an anonymous user titled "John Higgins, Sabotage of Kentucky" depicted Higgins standing by a truck bearing the insignia of his business. In the text at the bottom of the video, it suggested that viewers write a review of him here. Facebook.com/Rooferees. So they're saying, go onto his business and say mean things about him and how he's a mean, bad ref. Okay, so we're spurning on the mob and a little mob hatred as part of our displeasure over the sporting event. All right. The day after the game, the radio host, Jones, devoted time to Higgins refereeing. He read one email from a listener who contemplated leaving a bad review on John Higgins' roofing Yelp page. He's getting some blowback on Yelp, too. Jones, the radio host, responded that this would be a bad thing to do, and it might constitute harassment. Jones read another email from a listener who was against trolling John Higgins until he saw the name of the roofing company. The name is not particularly helping. Jones laughed that Higgins went with the name Rooferees. Even so, he didn't think fans should troll the guy. So the radio host Jones over here is trying to at least bring it back a little bit, although he is bringing it up for ridicule and mocking at the same time. The same day, Drew Franklin, a writer for the Kentucky Sports Radio website, published a series of articles criticizing Higgins' calls. He followed up the next morning with an article commenting that Higgins' roofing business was getting crushed on his Facebook page. He stated that he wouldn't link the page because he disagreed with attacking Higgins' side hustle, or his main hustle, because it's probably how he gets most of his business. He nevertheless posted a link to the video for those who could stand to watch it. So, yeah, the writers and broadcasters of Kentucky State Radio, Sports Radio here have some things they'd like to say about Higgins and his sporting calls. Fun. Franklin added that Kentucky Sports Radio does not condone the activity occurring on the pages, but at the same time, he and others reproduced at least dozens of comments that were posted there. One of the comments suggested Higgins' roofing business takes money from under the table from the mafia in Vegas. Another wondered if Higgins used illegal labor, substandard materials, and shady accounting practice. Yet another accused Higgins of hitting on the commentator's 13-year-old son. The fans are pretty salty over here, making up some really bad accusations, man. Yeah. Jones returned to the air. He raised the topic on Higgins' Facebook page and the abusive comments. He admitted to finding some of the comments funny and asked how many of those commenters would like to write for Kentucky Sports Radio. So the writers of Kentucky sports media and the broadcasters of Kentucky sports media are having some fun over here at Higgins' expense. They're making some major things about his blown calls, or at least saying that he did. And now he's getting trolled on various things, and he is saying that these things are funny and maybe you should write for us as writers, jokingly, or not. So either way, it's like, so Higgins is displeased with all these things that are coming his way as a result of these sports calls. So I don't know what the operative lesson here is. Maybe don't get into reffing as a sports guy, but the fans don't appreciate it if you make the quote-unquote wrong calls. You know, as a legal commentator who has enjoyed just the slightest bit of blowback for quote-unquote wrong legal calls, I can only begin to imagine the hatred that comes from the NCAA officiating. So maybe I won't go down that particular career path. I don't know, man. Maybe it's not worth it. The trolling campaign took a toll on Higgins' business. It received over 3,000 phone calls in the 2 days after the games, with some numbers calling 40 or 50 times a day. The calls crashed the voicemail system and made it hard for customers to get through. Higgins received many false requests for service. Reputational harm followed. WeatherGuard Roofing went from being a top-rated business in Omaha, Nebraska, with 4.8 stars out of 5 on Google, to being one of the worst-rated, with 1.2 stars out of 5, based on 181 false reviews that were placed. Higgins closed his Facebook page to stem the bleeding. Threats also came to his family, which is really just like, you know, that seems a little bit beyond the pale, but some people take this really seriously, I guess. The business received over 800 threatening calls, and his home received 30 calls. At least a dozen of these provide a basis for criminal investigation for true threats. When Higgins refereed a Final Four game later that year, a bodyguard had to accompany him. So the threats were really, really serious, and he had real problems as a result of this. So I don't know what the operative lesson here is. Don't be a referee for basketball games, I guess. Higgins sued Jones, Franklin, and Kentucky Sports Radio, alleging intentional infliction of emotional distress, invasion of privacy, tortious interference, and civil conspiracy. So he wants to sue for all the mean things that they said and for, helping his business, basically suffer and fail. Higgins raised 7 causes of action, but they all ultimately reduced to a single theory of liability. No matter the label, Higgins claims that Kentucky Sports Radio owes him money for damages for unfavorable statements about him and his roofing business after the North Carolina-Kentucky game. The First Amendment, however, bars this theory and the claims of record. So, as is often the case in these things, the First Amendment does come up to play. And there is a difference between critique and commentary and defamation and other things. So if people want to critique you being a bad player or a bad ref, they can critique you. They can criticize you. And a lot of this is protected speech. Now, some of it's not, but these people aren't responsible. So whether or not other people are responsible for their true threats, other people might very well be responsible, including criminally. But whether or not Kentucky Sports Radio is responsible, no. Because Kentucky Sports Radio didn't do anything to defame him. They merely criticized him and poked fun at him for the blowback he was getting as a result of it. So, they're covered by the First Amendment regardless of what might be true for others. The First Amendment safeguards freedom of speech and of the press. It does so to promote free flow of ideas and opinions on matters of public interest. Because open channels of information must account for the possibility of inappropriate or controversial speech, the bedrock principle underlying the First Amendment is that states cannot prohibit speech merely because it offends the sensibilities of others. That is why commentators may invoke the First Amendment as a defense in state tort suits aimed at punishing them for their speech. Whether the First Amendment presumptively shields commentary from liability turns on whether the speech may involve a public or private concern. What is a public concern, therefore? The subject of legitimate news interest or a subject of general interest and of value and concern to the public. What is a private concern? Everything else. No bright line separates one from the other. Courts instead look to decisions as guideposts, assessing how the content, form, and context of speech compares to speech at issue in cases as revealed by the whole record. So, what is private speech and what is public speech is often a determining factor in these things. And what is public speech is something that's of public interest. And is this public speech? Yes, because it concerns a public game that he officiated publicly. So people want to criticize his officiating, that's pretty public. It's a matter of public concern. So it's not his private affairs or his things. It's dealing with his reffing. And so at least as far as Kentucky Sports Radio goes, not to deal with anyone else's liability because things about his business might extend beyond that, so other people might be responsible. But what Kentucky Sports Radio did, not so much. Kentucky Sports Radio coverage of Higgins falls on the protected side of this line. Sports like basketball make up a multi-billion-dollar business nationwide, and prominent sports programs at major public universities count as matters of great interest to the relevant communities. That sports coverage implicates public concerns is amply demonstrated by elaborate sports sections in every daily newspaper published in this nation and numerous periodicals exclusively devoted to sports. The same considerations place officiating within the sphere of public concern. Whether true or perceived to be true, a referee's calls can change the outcome of a game. When they do, fans have every right to read about and discuss the manner in which the referees called the game. All this deserves coverage. Just as commentators must be able to discuss the quality of officiating, they must be free to comment on the fans' reaction to that officiating. That means Kentucky Sports Radio could fairly discuss the game and could fairly criticize those who participated in it, including the referees. Sure, some Kentucky fans likely tuned into Kentucky Sports Radio coverage of Higgins solely for the Schadenfreude. As a person who loves the Schadenfreude, yeah. But even if discussion served only that purpose, the discussion's inappropriate or controversial character would not influence whether it is a public concern. Higgins objects that whatever Kentucky Sports Radio's gripes might be about him, it should have left his roofing business out of it. But the commentators did not attack his business on its own right. They discussed it in the context of general issues with Higgins, which concerned the way he drawn the game. Higgins also targets a bootstrapping problem. He argues that Kentucky Sports Radio fanned the flames of harassment, and therefore it cannot use the fact of harassment to justify its coverage. He's correct that an entity sued for speech cannot, by its own conduct, make a public figure. So you can't bootstrap your way into public concern or public figure. That is not a thing that happens. So you can't force someone into public figure. You can't force them into public status. But that didn't happen because Kentucky Sports Radio had adequate freestanding coverage. It had the justification of his public participation. So you can't, by the controversy that you create a matter of public concern that allows you to defame people. You can't do that. You can't bootstrap your way into it. But you can, if it's already a matter of public concern, comment on that. And an NCAA basketball game will certainly do the trick. That Kentucky Sports Radio commented on a matter of public concern solves half of this puzzle. But not all speech receives immunity from sanction in the form of damages. States have long possessed the power to prescribe active advocacy of illegal conduct. So you can make it illegal to advocate for illegal conduct, but only under some narrow circumstances. So what are the circumstances under which you can prevent people from advocating illegal conduct? When is that illegal itself? The First Amendment limits those only to those punishing, to those that are directed to, inciting or producing imminent lawless action. So in general, you can advocate for illegal activity as long as it's not imminent. Incitement requires three showings: that the speech explicitly or implicitly encouraged the lawless action, the speaker intends that it will result in a lawless action, and imminent use of lawless action. So states can prevent you from advocating illegal things that are going to happen right now, but they can't prescribe things in general. So in general, it's okay to say people should violate the law, not just you should violate the law right now. So you can only look to speech that encourages the illegal action, that you want to have the illegal action, and illegal action is going to happen right this second. That the government can prevent. Otherwise, it's freedom of speech. Higgins adds that even as members of Kentucky Sports Radio technically said the right thing, they nevertheless encouraged his harassment by dog whistling the fans, so they're dog whistles, telling him to leave alone only by wink and nod. It may be that preventive sarcasm could transform innocent speech into incitement. Say a speaker provides step-by-step instructions encouraging lawlessness, each preceded with a sardonic nod. For instance, I do not want you to visit Higgins' page. I do not want you to leave a one-star review. I do not want you to do all that as soon as you get off work, and I do not want you to tie up the phone lines. But that doesn't describe the case. Kansas Sports Radio did not advocate for Higgins harassment, either, overtly or with sardonic platitudes, nor did disavow the fans' conduct smack of irony, usually. Yes, it did a poor job of dissuading listeners from mischief, but a party cannot sue for incitement merely because it fails to condemn the behaviors of others with sufficient firmness or clarity. Whatever the status of torts under Kentucky law might be, a plaintiff could not prevail without carrying the same First Amendment burden he would carry in other cases. That means Higgins must be able to show that Kentucky Sports Radio acted with actual malice because it's a matter of public concern. That is, making knowingly false statements or acting with reckless disregard of the truth. Merely repeating potentially false reviews generated by others may be in bad taste, but it cannot itself constitute defamation. And a good thing, too. If it could, any news article discussing a Twitter exchange could land its author in front of a jury. That would make authors of the First Amendment cringe. So merely repeating stuff other false people said does not get you past public figure status or public concern status. That is not actual malice. Thus, that brings us to the end of the case of John Higgins versus Kentucky Sports Radio. In this case, Mr. Higgins was an NCAA basketball ref, and he made some calls that displeased the fan base of the Wildcats. And it didn't go well. And they came after his business too. And he tries to sue Kentucky State Radio. Now, he may have causes of actions against other people, including some of the people that led harassing reviews or even threatening reviews on his website or otherwise, or his voicemail. So there might be criminal exposure for other people. There might be civil exposure for other people. But is there exposure for the Kentucky Sports Radio? No. Because what they did was within the bounds of the First Amendment, critique and commentary. And the fact that they said mean things and highlight the mean things does not a defamation suit. So whatever else your cause of action might be somewhere else, not so much against Kentucky Sports Radio, they're within the bounds of the First Amendment. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.